Okay, let's get started. Hello, everyone. Welcome to the ICANN76 update. This is the update on the ICANN policy meeting that just happened last week in DC. And I have with me Mason Cole, a longtime ICANN participant. Mason has been involved in internet domain name expansion, issues management, and brand protection for more than 20 years. A recognized leader in internet governance, he serves as chair of ICANN's business constituency, where he's a vocal proponent of responsible policy development for business users and brand owners. A couple of quick housekeeping notes. We're going to try to keep this session to 30 minutes. And then, as Rebecca said, you can submit any questions in the chat and we'll answer them at the end of the session. Okay, let's get started. Next slide. So here's some of the topics of interest that we thought that we would highlight for everybody. The domain name registration data policy update, the transposition of NIS2 directive in Europe, the ICANN contract amendments that are to address the DNS abuse, and really the sub-pro next steps in the new round of generic top-level domains, the GTLDs. Next slide. Okay. So we're going to start now with the domain name registration data policy update. As everybody is probably familiar with by now, the WHOIS is the ownership record for a domain name. And it's like your car registration, right? Or your residential property record. It tells you who is behind a particular domain name. It serves as a means of identifying who is behind a scam maybe, or an infringement. And prior to GDPR, we were able to get that WHOIS information through port 43. But after GDPR implementation, the ability to get that information in real time was seriously compromised. So now the only way that you can actually get that information, which is that WHOIS information, who is behind the domain name, is by asking the registrars for it. So the next slide. Problem is there's 2,000 plus domain registrars out there and really no standardized process for asking for that information. So in fact, you might ask some registrars for the information, then they'll say, well, send us an email or go ahead and fill out a web form. And it's pretty much, the wild, wild west right now in terms of trying to get that information or trying to figure out how to get that information from each of the different registrars. And then when you ask for the information, and it has to be for a legitimate purpose, such as phishing or trademark infringement, the registrars will then perform a balancing test to determine whether or not to hand that information over to you, right? So that balancing test is, we're going to balance the privacy rights of the person, that person over the need for the requester to have that information. So that presents problems in itself too, because right now the responses that you'll get back from all these different registrars might be, go get a subpoena to be able to get that information, or they may not even respond at all. Let me add that this company, Tracer, has had the same ticketing system since 2018, and there are a number of registrars that do comply with the requests that we've been sending out. But we have queried not only the registrars, but we also query the registries and the proxies, and have about a 30% success rate on getting that compliant information, which is the information behind the ownership information behind the domain name. I think with the RDRS, and maybe this is hopeful thinking, we might have more registrars participating in this process, because if they opt in and the brand holders aren't sending any WHOIS information or any WHOIS requests out there, well, the argument that we'd be handing over to the registrars is, well, maybe that information isn't as important as people are saying it is. So you wouldn't get back to this later on, but it's really critical that we ultimately end up using the RDRS. Let me emphasize that the registries and the proxies are not part of this process, this RDRS system at this time, but that's at least for now. That might change later on. Next slide. Going back a ways, ICANN originally had a more comprehensive system it was actually thinking of coming out with, which was called the SAD, the standardized system for access and disclosure. And that was going to be a system that would actually send and receive the data, and everything could be analyzed within the system itself. But obviously at 20 to 27 million, that cost was prohibitive. So instead they opted on a ticketing system, which was cheaper and could be implemented faster. So that's how we've come now to the ticketing system, which is the RDRS. But the RDRS though is it's a little bit more like a routing system, right? So it'll take your request and then it's going to route it to the sponsoring registrar. So at this point, it appears that the response is not going to be coming back into the system, but it'll be sent directly to the requester. So if you think about it, the request goes into the RDRS, and then that gets sent over to the registrar, and the registrar is then going to be sending any information back to the requester and not back into the RDRS system. So everything is going to happen outside of that system. Problem with that I see is that the system is not going to be able to capture all the information that would come back, which would be, well, we're not going to answer this, or we refuse to, you got to give us a subpoena, or whatever the response is. That's not all going to be captured within the system if it all happens outside of the system, right? So it's incumbent on the requesters to be able to be capturing all that information, and hopefully at some point we could take all that information and then analyze that as it's coming in. Clearly, the RDRS is going to take some time and probably won't be implemented till late 2023, maybe November of 2023. And as I said before, it's an opt-in for the registrars. So the registrars are not required to be a part of the system, and the registries are not a part of the system, and neither are the proxies. Okay, so next slide. I don't know, Mason, if you want to add anything to that at all.
No, you captured it pretty well, Faisal. It's going to be a kind of a bare bones system in terms of the ability to actually capture data. The registrar can follow up separately from the RDRS. They'll perform the balancing test and let you know whether or not you deserve to have the data. And then it's really important. I know you're going to cover this in a minute, but it's really important for users to utilize the system so that ICANN can get a true measure of demand. That's really the proof of concept behind this proposal is measuring demand.
Yep. So yeah, let me emphasize that again, because this is really, really important. It is a proof of concept, and it's intended to gauge the demand for who is, right, whether companies really need it or not. And registrars have been saying for quite some time that the brand really don't does it care about the information. It's not, there's not a huge amount of demand for it. And when you really think about it, there's a reason for that. There's a reason why you're not seeing a lot of requests going over to the registrars. And that's because in most cases, brand holders will send cease and desist notices to registrars asking for the domain to be deleted or taken down, right? So you're going to send a cease and desist, there's an infringement, you're going to send a cease and desist, you're going to ask them to take it down. You're not asking the registrar to also give you who is behind that information. Now, so that there's where the issue is, right? So some registrars or some brand holders will say, well, I want to get going right away. I want to be able to get the takedown right away. I don't want to have to wait around for the information. But maybe there's a parallel path where you can send a cease and desist and also say, and we also want to know who is behind that domain name as well. And the reason for that is, if the registrar does take the name down, the name gets deleted. I mean, that thing could pop up, 2 days later or the next day, and it might be the same registrant that is registering that name again, right? Well, you'll never know unless we're getting that information as to who is behind it, right? And I think that's what you're saying, Mason. That's the key here, is getting as many people and getting everybody, all of us, because we plan on doing that here at this company, to go out and start asking for that information through this RDRS system. The other thing that we find is that this is really a system that's over reliant on registrars, and there's no registries and or proxies that you can submit any request to. So it's all about the registrar. So we definitely need to send stuff into the RDRS to be able to put some pressure on them to be able to provide us with that information. Next slide. So long-term impacts. Ultimately, I believe if we don't see continued impact for WHOIS, then ICANN will simply put, all the WHOIS issues that are currently, out there that could be coming up for discussion. They'll just simply put that on the back burner, and then you'll continue to see more issues such as the NTIA removing WHOIS information from .is. You'll continue to see issues like that crop up. Now, maybe that's something, Mason, you might want to discuss as to what's the rationale behind it, but to take away the WHOIS from .us could be particularly problematic if it turns out that, you start seeing it on that extension. Anything to that?
Yeah. If I just add some color to that, the NTIA proposal came out just before the ICANN meeting in DC. The rationale behind it is to protect the privacy of .us registrants, of course. The comments that have been filed so far that I've seen on the part of the BC and inside of ICANN, which I chair, and other active participants inside of ICANN who have a business or IP or other legitimate interest in the WHOIS data, is to tell the NTIA your danger is not so much the privacy of registrants. Your danger is in letting the .us namespace get corrupted to the point where you have the same difficulty you have in other TLDs, which is where the database is not public. You can't identify at scale who the offenders are, and you can't take down the offenders in a meaningful or efficient way. So we're hoping NTIA sort of comes to their senses, but they are getting congressional pressure. We know to see about doing something with a .us namespace. Now, that is in contravention of the NTIA's historical stance on the importance of WHOIS. They sort of reverse their position. So we're hopeful, but not necessarily counting on the outcome.
Yeah. Is there a comment period or anything around that, Mason?
Yeah. It may be closed already. I'd have to check, but there was a comment period open. I believe it closed right before the ICANN meeting.
Interesting. Okay, next slide. So as Mason was saying, we need to use the RDRS system because we've got to be able to document all that user demand. It's basically an imperative for all of us. If we don't use it, we might potentially lose it. Also participate in an ICANN 78 in Hamburg. That's in October, I believe. And we are, brand owners and businesses are being sought after to share all their experiences with the WHOIS, so that we will see that we can see that like systems like the RDRS will continue to be something that stays in place and doesn't get taken away. The other thing that you can do is also participate in groups like the ICANN and the business constituency that Mason is a part of. And if anybody wants to participate in any of those committees, we can put you in touch with Mason, and Mason will explain to you how you can get involved. Okay, Mason, I'm going to hand it over to you here.
Okay, thanks, Faisal. All right, so I'm going to cover the next three subjects. We've got about 15 minutes left, and it shouldn't be too much of a problem because the WHOIS issues that Faisal covered are really the biggest priority probably for this audience. But let me cover another few issues that were addressed at ICANN77 and have been historically, for the past several months anyway, important to the internet governance community. And the first is what's known as NIS2. NIS stands for Network Information Security. 2 means this is the second version of that directive that was published by European Union authorities. What is it and why is it important? It's a directive from the European Parliament that is mainly cybersecurity focused, but it has some very targeted provisions relating to who-is data. And I'll cover that in a minute. It's Article 28 of the NIS2 that you really want to pay attention to, because it spells out the treatment of who-is data. So the directive came into force in mid-January of this year. It is now under a process called transposition, which is when the 27 member states of the European Union look at the directive. They take the language, they transpose that into a binding law in each of their countries, and their deadline for doing that is October of next year. So they've got I don't know, a year and a quarter maybe left to do that. Several countries have already published their proposed transposition language, and we're taking a look at that to see which jurisdiction has the strongest language and which has the weakest language, because that'll have an impact on how registrars behave in terms of their treatment of data in the European Union. The good news is there are several provisions of NIS2 that clarify treatment of who-is data in a way that can be helpful to brand owners, and we'll talk about that in a minute. Next slide, Becca, please. So what does NIS2 say about who-is specifically? It makes some helpful clarifications about the treatment of the data. First, it has to be accurate and complete. It needs to be made publicly available not only to law enforcement, which is sort of the traditional, first in line participants in the who-is database, but all who-is data that is not personal data, meaning data of legal persons, can be made publicly available. That's not all the way to the end goal of what we want for who-is, but at least it's a helpful step. Registrars and registries are required to respond without delay. The deadline is within 72 hours, which is not really without delay, but when you're in the middle of an important investigation, you need the data within more like 72 seconds. But there is no SLA or a provision about response times, and this puts a response time into place for registrars. And then you have to provide legitimate access to who-is free of charge. And there are registrars who are charging for who-is data right now. That's been clarified to the point where it should not be charged for. All right, next slide, please. Okay, status of NIS2 is that there are 27 European member states. As I mentioned, they have 21 months until October to transpose the directive into binding jurisdictional law. Member states are now cooperating on what are called implementation guidelines, which means, excuse me, there's sort of a group of member state participants who are putting together implementation guidelines that will guide member states' transposition of the law or the directive into law. There is potential for detail level differences in implementation in various jurisdictions. The reason that's important is because registrars and registries are most likely to go to the lowest common denominator and behave according to that lowest common denominator. So whatever their least amount of responsibility in responding to who-is requests might be across all the member states, that's probably the one they're going to follow. So it's important to get as strong a set of implementation, transpositions and implementations in member states as possible. Okay, next slide. What should brand holders do? Well, if you're in Europe, keep an eye on what's going on with who-is related provisions. Again, that's Article 28. As Faisal mentioned, you should participate in ICANN78, where NIS2 will be very extensively discussed. You need to participate in INTA and other trade associations that are active on NIS2, because that's where your voice is going to get amplified. And it is important that as many voices as possible are heard on this, because otherwise the contracted parties are going to be out lobbying us, and we don't want that. Okay, next slide. Okay, let's shift now to DNS abuse. So what is domain name system abuse? It depends on who proposes the definition. The registrars and registries I have to tip my hat to them. They've done a very good job of lobbying ICANN to define DNS abuse as only 5 things: malware, phishing, farming, botnets, and then spam as a delivery method for those first 4 forms of abuse. And I'll get to the contract amendments here in a minute, because that definition is important in terms of how the contract amendments have been formed. But I want to point out that other definitions have not been so precise, and they strive for additional latitude to anticipate emerging threat vectors. It's kind of like the old Supreme Court argument where I can't remember the name of the justice, but he said, I don't know how to define pornography, but I know it when I see it. It's kind of the same way with DNS abuse. You don't necessarily define it as narrowly as possible, but you do know it when you see it, and there needs to be more latitude to anticipate where the threats are going to be coming from down the road. Next slide. So what's being done about DNS abuse in the ICANN contracts? And this is a result of the pressure the community has put onto ICANN.org and contracted parties. So as you probably know, ICANN accredits registrars and registries, enters into them with accreditation contracts, which permit them to either wholesale or retail domain name registrations. It also spells out expected behaviors on the part of contracted parties. The contracts right now are weak in the area of DNS abuse. They don't give ICANN, the ICANN compliance department, really enough teeth to pursue the contracted parties that intentionally harbor various forms of abuse. What we've been pressuring ICANN for, and now is finally being accommodated, is those contracts are now being updated to establish a duty for registries and registrars to act on abuse, not just investigate it and take appropriate action, which is what the contracts now say. So I think we're going to cover the specific language here in a minute, but registrars are obligated to disrupt or put a stop to DNS abuse, which is a real step forward. Next slide, Becca. These are the kinds of amendments that have been proposed. So there are, I don't want to read all of them here because there's a lot, but if you focus on the last one where as I just mentioned, contracted parties have to focus on the target outcome of stopping or disrupting the use of GTLD domain names for DNS abuse. Now, that may only be limited to the forms of abuse that are defined by ICANN.org and the contracted parties, but again, at least it's a step forward. Now, there will be additional policy development around DNS abuse. That's a longer term prospect. I'll cover that in just a minute, but at least we've got a step forward with contracted parties. Next slide. These amendments are open for comment until July 13th. Very much encourage you to take a look at those amendments. If you need some guidance on how to make the comment, I'd be happy to help. I think the business constituency or the IPC would be happy to help as well. But those comments are open until mid-July, and it's very important that the user community, the business community, the brand holders community makes their voice heard, because otherwise the environment will continue to be dominated by contracted party interests. Next slide. Okay, what happens after the conclusion of negotiations on the comment period? Believe it or not, registrars have to ratify this. And so 90% of accredited domain name registrars have to vote to ratify the amendment to allow the contract amendments to enter into force. This is going to take a while because there, as you might anticipate, there are bad guy registrars out there who don't want additional provisions put onto them about how they behave, and they probably will not vote to ratify. And so it's incumbent upon the registrar community to try to get as many of their colleagues to vote to ratify the amendments as possible. Otherwise, we're sort of back to square one. And then I mentioned there's further policy development in the works. That's probably going to take, more like 1 to 2 years to sharpen various penalties for DNS abuse. But that's the next step in the community. Okay, next slide. Lodge your public comment. That's where you go to do it. Or just go to your browser and type in ICANN comments and you'll find it. Okay, we're getting short on time. I want to make sure that we get through this. But in terms of the new GTLDs, not much of an update out of ICANN77. As you know, GTLDs are the generic words that follow the dot in a domain name. I don't mean branded or geographic terms or country code TLDs. ICANN is considering additional GTDL expansion because there's pent-up demand for more specificity in the namespace. There is opportunity for further participation in that expansion by economically disadvantaged areas in the global south, all of whom were underrepresented in the 2012 round of new TLDs. Next slide. What's happened so far? We spent 2 years talking about it, kind of in typical ICANN fashion. This is a process known as subsequent procedures, or sub-pro in ICANN parlance. Not much happened at ICANN77 in DC, but ICANN org is under a lot of pressure to show some results out of the bottom-up model that they employ, because they've been stagnated in terms of progress for about the last 6 or 7 years. And so, excuse me, they will continue to prioritize new GTLDs. One outstanding issue is the issue of closed generics. What that means is you might have a TLD applicant apply for example, .hotel, say it's Marriott or Hyatt or somebody like that. And through a generic term, a generic dictionary term, they present only advantaged search results from their corporate entity or their brand. Chances are those are going to be done away with, but that's a big issue right now. How soon? Here's the payoff pitch for this audience, which is how soon are they going to become available? The answer is not for a while. My guess is at least a couple of years. There are lots of things underway that will need to be considered before a registry can even apply to run a new TLD. So I think you've got some breathing room in terms of getting yourself teed up to protect your brands in new TLDs, but it bears watching. Next slide. What should brand owners do? Well, I just said it. Nothing's immediate, but keep an eye out. You should know what kinds of GTLDs might become available. Chances are it'll be generics plus geographic terms and probably some brands as well. And then you should know about what types of right protection mechanisms are going to accompany the new round in terms of protecting your brand. And then keep abreast of developments through ICANN and INTA and other advocates for rights holders. That's your duty right there. Okay, Faisal, I'm done talking for a while. That was a good 15-minute blast right there. So I'll leave it to you.
Good work, Mason. I don't see any questions, unless you see some questions that I don't, Rebecca.
Here's one of the Q&A pop.
Yep, we just had one pop up. Any news on the ongoing depreciation of who is in favor of RDAP?
Oh, yeah, I can handle that one. Thanks, Sean, for the question. There was a contract amendment for registrars put into place. The timing escapes me, but I think about a year ago, to implement RDAP, which stands for Registry Data Access Protocol, and a Registration Data Access Protocol. What it is, it's the technical system that underlies the provision of the data in the WHOIS database. My understanding is that is well underway and shouldn't be an implementation problem or anything of that sort. But it doesn't really affect the policy regarding access to the data. It's more the technical methodology underneath the data. So I hope that's helpful.
Awesome. All right. Rebecca, any other questions that you see?
Any other questions? If anybody has anything, this is the time to do it. I don't see anything coming through right now.
Well, thank you, everyone. Hopefully that was helpful, and we'll see you after the ICANN Hamburg meeting. Thank you very much. Thanks, Mason.
So long, everybody.